The Supreme Court heard a plea on the deportations of the foreign Tablighis who had taken part in the Nizamuddin Tablighi Jamaat Markaz. During the hearing, the centre told the court that the passport of 3,460 foreign Tablighis have been impounded. The centre also held that right to return home is not an enforceable right. However, the court said that the blacklisted Tablighis can appeal to the relevant authorities for their return back home.
The issue of deportation of foreign Tablighi nationals was heard in the Supreme Court. The bench of Justice A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna was hearing a plea filed by 34 foreign nationals challenging the decision of the Ministry of Home Affairs to blacklist over 3,000 of them from travelling to India for a period of 10 years. Solicitor General Tushar Mehta informed the Supreme Court that the centre had passed individual order to cancel the visas of over 3,460 foreign nationals who had taken part in Nizamuddin Tablighi Jamaat Markaz. The Supreme Court ordered that all the petitioners will be permitted to make representations before concerned authorities. It noted that since the centre had passed individual orders, the petitioners may challenge the same before concerned high courts. However, objecting to this, Solicitor General Tushar Mehta submitted that the blacklisting of an individual was a sovereign plenary function and that most of these individuals face criminal charges. He also submitted that right of return not an enforceable right. In response, Justice Khanwilkar stated that the centre can make these submissions before the competent authority. Senior Advocate Chandarudai Singh, appearing for the petitioners, stated that the main issue here was of right to return. He also submitted that none of the orders passed had mentioned anything about blacklisting the foreign nationals. Senior Advocate Dr. Menika Guruswamy submitted that the order passed by the centre against these foreign nationals were never sent to the petitioners. Thus, the court ordered that all such orders to be sent to the counsel for the petitioners via email. The case has now been adjourned to 10th of July, by which the date the petitioners are required to file a rejoinder to the affidavit submitted by the centre and also make representations before the competent authorities as regard deportation. On 29 June, the court had observed that there was only a press release stating how these foreigners were blacklisted and that the centre owned explanation on whether there are official orders from the competent authority cancelling their visas. Bureau Report.